The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
We have three cases for submission this afternoon. The first one is Mumm versus Jennie Edmundson Memorial Hospital. The second is Iowa Supreme Court Attorney Board versus Baumeister. And the third is In the Interest of LT, AT, and DT. The last two cases are submitted non-orally, so we'll consider them submitted. And we're ready for the oral arguments in Mumm versus Jennie Edmundson Memorial Hospital. Mr. Shanks?
Judge, may it please the court, counsel? My name is Randy Shanks, and I represent Mandy Mumm, who is the appellant in this appeal. This case deals with the trial court's duty to answer jury questions during the deliberation process. And after hearing 9 days of testimony that involved some pretty complex issues of negligence, medical negligence, comparative fault principles, released parties, after having all that, the case was ready to be submitted to the court, or to the jury. The judge instructed the jury that its general duty was to find the truth and do justice. And the judge told the jury that the way they have to do that is they have to follow the evidence that's been admitted and apply that evidence to the instructions given to them by the court. The jury then received the packet of instructions and the verdict form, and they went back and they began their deliberations. After deliberating for a while, the jury let the court know that it had some questions. The jury was confused and didn't understand question number 5, which was the comparative fault question. And they wanted some assistance from the court. So they put two questions together, and they gave them to the bailiff, and the bailiff took them to the judge. Those questions were, one, as related to question 5, if we attribute 25% fault to Dr. Milleris and 75% to CH, would Mandy only receive 25% since CH has been released? Second question was, if CH has been released, how are they still named in the lawsuit? So these were things that the jury wanted to know so they could process and deliberate and decide the case.
If you look at the jury instructions that are published by the Bar Association, they say that those instructions should be given at the time when a jury is instructed, and yet they weren't included in the original jury instructions. And additionally, let me find my note here. Additionally, section 668.35 says it should be instructed on, and a party has a right to argue that case. How come nobody requested that instruction from the beginning?
I think, Judge, I think it was an oversight, certainly on my part, and I think on everyone's part, not to see that as a potential issue in the case. I was pushing as far away from having the jury assess any liability to CH because they were a released party as I could, and I was trying to distance myself from them because I didn't want the jury to know that we had settled with them and that they had paid us a certain amount of money. So I don't think my attention was focused in that direction when we put the initial instructions together. I think that's why it wasn't included. But we soon discovered when the jury saw that as an issue that that was a confusion that needed to be addressed.
You're not requesting those instructions or at the beginning. Is there any waiver issue or any of that problem?
I didn't see that. I didn't find any Iowa cases on point, but I think in my brief there's some cases cited that talk about a particular set of instructions could be good when they're given, but then during deliberation something might come up where further instructions would be needed.
I have a different problem, Mr. Shanks. Well, I may have Justice Wiggins' problem too, but here's my problem. We don't have a transcript of the trial, correct?
Right.
Including even the last day where the jury's instructed, the closing arguments are given. You know, we don't know the exact timing of when this jury question came back in relation to the whole their whole deliberations. Isn't it pretty hard for us to assess prejudice or, kind of much of anything here without a transcript?
Judge, I don't think so, and the reason is, we know that the jury was given the case. We know that the jury began deliberating. I think it's important that the jury went through the 4 initial questions on the verdict form. And so they considered that both Dr. Milleris and CH were negligent, that their negligence was a cause of damage. And then when they got to the 5th question, they didn't understand how to apply the comparative fault statute. So I don't know that having an entire transcript of the trial or a transcript of closing arguments, I don't know if that would have assisted the court or not in trying to look at this, because really the focus is on what was going on in that jury room when they had the instructions, and when they issued questions and said, we have some confusion, Judge, can you help us? It's that particular moment in time that we're looking at and claiming that error was committed by not simply telling the jury, yes, you're exactly right. If you award 25%, yes, that's how much Mandy Mumm would recover from Dr. Milleris. So I don't know that all the other transcript would have been helpful.
How long had they been deliberating before these questions came out?
I don't have the exact time, Judge, but it wasn't very long. It was that same day. I think it was submitted around lunchtime, and I would say within a couple hours, easily they had the questions.
And after the court referred them back to the instructions, how much longer did they deliberate after that?
Not much longer at all. I would say maybe less than an hour, less than 2 hours. They returned their defense verdict that afternoon.
Mr. Shanks, your hypothesis, and I recognize it's a plausible hypothesis, is that the jury wanted to award something to your client against Dr. Milleris, but was confused. But I have trouble, the jury ultimately found Dr. Milleris not negligent and then didn't go any further. Surely the jury had to have known that if they wanted to award anything to your client against Dr. Milleris, that's not the way to do it, right?
I think what happened was, I think there was a group, as often the case, there's a group that said there's no negligence. There's a group that maybe said there was negligence. Then there's maybe another group of the jury that said, what does all this mean? How does this all interface together? And so they were confused about how to do that. And the interesting thing on that verdict form is the very first question says, do you find Dr. Paul Milleris negligent? Yes or no? And it says, if you say no, case is over. You get to go home.
But they found unanimously that he wasn't negligent. I mean, they had to have known that was not going to give your client any money, right?
Right. And I think what it goes back to, too, is the fact we were dealing with a released party. There could have been, and again, we can't ask the jurors, but there could have been some speculation about this released party. How much money did the plaintiff get from this released party? If we give her, because I had asked for a large sum of money, if we give her that money, is she going to get that all again if she's already been compensated? So I think what they were attempting to do is they wanted to make sure that only 25% was going to have to be paid by Dr. Milleris, and that was all that Mandy was going to get. She wasn't going to get some windfall amount. I mean, that's what I was thinking that they were going through. And if that wasn't the case, why would they have bothered to ask a question? Why wouldn't they have just said no negligence and been done with it?
Why would they have bothered? It seems like the trial judge's hypothesis, which was supported by what they ultimately did, is this was just a preliminary effort to go through the verdict form and make sure they understood it.
I mean, that's entirely possible too. But I think that's the problem when you have a situation, you've got lay people on the jury, never been on a jury before, there's some confusion about how this percentage business applies. And I think that's why they asked the judge for help. And when we were contacted by the court by phone and the judge says, well, what do you think? My response was, the first question, just tell them yes, that's a correct statement of the law. And that would help them then understand the effect of their decision. And that ultimately is what we want the juries in Iowa to do, is when they decide something, know what it is that they're deciding. They, not have any gray areas or confusion in deciding how to determine a case. And that's why that we think that it should have been a yes answer. And because the court didn't do that, that's why we filed the motion for a new trial, and then that's what's led us here today. We think that there is a substantial amount of case law in Iowa that talks about what should be done when a jury is confused, and we would submit to the court that this is such a case where there's obviously some confusion because of the questions, and we don't know what was going on behind closed walls. There could have been a group of people that said, we will let the plaintiff have some money and make a recovery, but we want to know it's only going to be 25%. We're afraid that it might be something else and she might get a windfall. So there could have been that debate, and then when the answer came back, just go back to the instructions, it could have been, well, I told you so. We don't know, and we're not going to do anything. And that might have then deflated our advocates on the jury, our advocates' position that she should get something because it was gray and they were confused and didn't know. I think I've raised all the points that I want to raise because this is a pretty straightforward question, but I like the dissenting opinion in the Court of Appeals decision a lot, and I did like what Judge Doyle wrote, and I'm going to quote it if I could. With no guidance, the jury was left to blindly flop around in those murky waters of comparative fault. I cannot say justice was served under the particular circumstances presented. I therefore believe that Mandy is entitled to a new trial. And we would ask for the same. Thank you.
Thank you, Mr. Shanks. Are you going to go first?
Yes, Your Honor. Thank you, Your Honor. May it please the court, counsel. On the time issue, the verdict form went to the jury, I believe at 12:30. I was going to start my vacation straight from the courthouse. I had a motorcycle in the parking lot. At 2:01, we get the question. I'm still at the motel. We get all the lawyers together. We respond. By the time I get to the Harley-Davidson dealership south of Council Bluffs, we had got the verdict, which I think was at 3:56. So it was about an hour after they went back to the judge went back to the jury with the answer to the question, that they turned around, supposedly according to the plaintiff's theory, and returned a defense verdict. I realize the part about my vacation is not in the record, but if you put those times together, I think those are accurate.
I ask a
Did
question?
they order lunch too? At 12:30, I assume they would have ordered lunch.
Yes, and so a relatively short.
Mr. Ellwanger, will you stand in front of the mic so that?
Yes, sir, I'm sorry. So anyway, I've got 3 points to make, and my co-counsel will.
I have a question.
Yes, sir.
It's pretty clear to me the code requires the court to be the jury to be instructed on this, and you'd argue the effect of it. We don't have a final argument, so I don't know if anybody argued the effect of it. It's pretty clear that the Iowa Bar Association instructions tells you to give that instruction if there is a release party. It's
True.
pretty clear. So in my mind, I think Judge Doyle was partially right that the law required it to be given. Why, under these facts, was it not error not to give it?
Because it wasn't error because nobody asked that particular damage instruction be given. So now we are in the realm of supplemental instructions. And the case law clearly says that if you're going to reverse a verdict, and I think this is true whether you're talking instructions or supplemental instructions, you have to prove prejudice. And where a jury under the facts of this case, return a defense verdict in a relatively prompt period of time, it is impossible, without major speculation, for this court to find that the plaintiff has met her burden of proving prejudice. Now, if you look at the case law where they discuss, is there prejudice or is there not prejudice, and the cases even say, in some cases, there can be a presumption of prejudice if bad instructions are given. But the cases also say bad instructions as to a significant element of the case. And in this case, where they make a defense, where they render a defense verdict, it is not a significant element of the case. If they had been given bad instructions on liability, then it would be. And one case that is cited by the court, by either side on this was Harrington, which is from Arizona. That was a case in which the jury wanted to know whether a one-year statute of limitations for construction applied to the case. That goes right to the heart of liability. Then there was the Everett case, which is a criminal case in Iowa, and the jury wanted to know whether or not you could be held guilty or found guilty of first-degree robbery if you don't have a weapon on you. These are examples of instructions that are necessary, that are significant, and go to the heart of the case. Well, I'm not going to necessarily agree with Your Honor for this reason. There are a series of 6 instructions on comparative fault. And they start out with the statement of the case. Dr. Paul Milleris and Jennie Edmundson Hospital claimed that CH Inc. was negligent, and it was the negligence of CH Inc. which caused injury to the plaintiff, Manny Mumm. Instruction 17, Instruction 24, Instruction 21. The verdict form was CH Inc. negligent. Was the negligence of CH a cause of any damage? And what is the percentages to be allocated between Milleris and CH Inc.? I think there are adequate instructions here for the jury to comprehend the nature of a comparative fault case. Now, for years, I've always wanted to use in closing argument the old instruction to the jury that says, you are the judges of the facts. You aren't the judges of the law. You aren't the judges of the application of the facts to the case. Well, I realize that when if you follow this recommendation, that you're asking the jury to consider things that are beyond the facts. But I fail to see where a failure to give that instruction is prejudicial, because the jury is there to find the facts. Is there liability? And to me, that is the essence of what the jury is supposed to do and what they did in this case. For the plaintiff to prove prejudice in this case would require this court to engage in extreme speculation, that the jury had gone through all these instructions.
Isn't it simpler than that? In order for us to find prejudice, we're going to have to see what the jury talked about, and you can't do that to overturn a verdict. You can't invade the deliberation. So I don't know. You know, regardless of speculation, the real answer would be an affidavit to somebody, but we can't use it.
You can't do that. And at one time in my career, I've gone and gotten affidavits, and I ran into this very argument. But the only way that this court can engage in that speculation is to invade the deliberative process and say, oh yeah, they were all ready to return a plaintiff's verdict. And when the judge wouldn't clarify comparative fault, they all flipped. And that just doesn't have compelling logic behind it, and it certainly doesn't meet the requirement of the case law that says that someone in the plaintiff's position does have the burden to prove that there was prejudice due to this instructional error. And that's true of all instructional errors. They have to demonstrate prejudice. And that, to me, is an insurmountable problem in this case. So Mr. Shomaker is the other half of our team on this case, and I'll let him do the second half of the argument. Thank you.
Mr. Shomaker? He did leave you half the time.
I left with at least a couple of minutes, I think. Oh, not bad. Hello, my name's Tom Shomaker. May it please the court that I present my argument to you. Counsel, nice to see you. Some of the things I've been hearing here are relevant to the argument I was going to make, but to boil down to things I think we ought to consider and keep our eye on the ball here is this is a case of abuse of discretion. This is a case in which the appeal was taken because Judge Steensland said, go back and read the jury instructions, and then we had a defense verdict, and that was the appeal was taken on that ground. It has nothing to do with instructions. If the wrong instructions were given, okay, that's a different standard, and there should have been an appeal on that issue, and there wasn't. We're just here to answer one question. Was this an abuse of discretion for Judge Steensland to say, go back and reread the instructions?
Yeah, but abuse of discretion can be a failure to follow the law. It's not just untenable or reasonable, and I don't think the Court of Appeals picked up that point, and it's clear the code says instruction shall be given on this point. So
Well, if
why
I'm-
wouldn't it be an abuse of discretion?
Well, and in my view, reading that 668.3 subsection 5 that the dissent honed in on, if you look at that, that's got to be submission to the jury. That says nothing about.
Isn't there case law that says if something is omitted from the original instructions and then the jury asks a question and a correct legal answer can be given to the question, it should be given and could potentially be an abuse of discretion not to give the right answer?
Well, we're getting into the should and could and must and will and absolutes, and that's what I don't think the law is very clear about. The law in this state is, your Iowa Rules of Civil Procedure make it clear that the court may give additional instructions when asked in a situation like that. It's not a duty, as Mr. Shanks suggested to you when he stood up here and told you this is what the appeal was about, because it isn't a duty. It is a discretion that the court should have, and you have no record, nothing to look at. All you have is Mr. Shanks' motion for new trial in which he assumes that there was confusion, that the jury must have answered questions 1 through 4 in the affirmative, and that they wanted to give money away. Well, then in that case, where's the jury verdict form with 1 through 4 filled in? We only have one jury verdict form. It's got a big X on question number 1, was Paul Miller's negligent? And the answer that they gave very quickly, the times were 12:30 when they got it, 2:01 when they asked the question, and by 3:56, after everybody had been assembled together, the verdict was rendered. And all of that is on the record from what was submitted to you, this very small bit of information that you have. You've got jury instructions, you've got Judge Steenland's order. That's about it. The rest of it is speculation on Mr. Shanks' part about what might have happened, could have happened. Without a record, you can put that to bed. This
Well,
appeal.
Let me
Yes.
ask what the downside would have been to answering the instruction, or
I
to
get-
providing it.
I guess, maybe there is none, but again, two things. If the court has said, and the rules say, that the discretion of a judge to maybe answer a question, who's listened to 9 days' worth of testimony, who knows what this thing is all about, and we could go off on a side trip of all kinds of things that happened in that trial, but nothing's on the record, so I won't go there. I'll just say that we don't have a way to know. But Judge Steenland did know, and in his discretion, in his judgment, it was
But I usually want
unnecessary to do anything
more of an
further.
explanation. I mean, I may buy your standard of abuse of discretion, may well be correct, and generally, trial courts get some healthy discretion. But we need to know, what's in the balance here. And on the one hand, arguably at least, it's a correct statement of law that's arguably mandatory, although wasn't requested, and that's the trouble for Mr. Shanks, I think. But I'm trying to figure out in his discretion, what is being weighed, what are the pros, what are the cons? Going to give him some healthy breathing room, but the cons, This wasn't that hard. I mean, I don't think. It wasn't like, oh my golly, I'm gonna confuse the
Well, it's
jury.
just, if we're speculating, maybe it is.
Well-
Well, it's kind of hard when, in the context of this case, when you don't have a record, and we don't know the significance of this released party language versus, if we look at 668, subsection 3, subsection 5, settled party, they're totally incongruous, okay? And there is a little dance that's got to be made there that we're not going into because we don't have any record on it, okay? But that would be a reason why, in a judge's discretion, before I'm going to answer a question and maybe go down a rat hole that we're going to never come out of and offer an appeal to everybody, I don't think we should do
It
it.
strikes me, the first question, if we attribute 25% fault to Dr. Malaris and 75% to CH, would Mandy only get 25% since CH has been released? I mean, that one did have a straightforward answer. The second question, if CH has been released, how are they still named in the lawsuit?
Little dicier, yeah.
And maybe
Maybe
the
answer one
judge thought it
question.
was safer to answer neither of them than
You know,
answer one and.
Should he have answered the first one and then deferred on the second one? You know, I mean, that's putting a lot on a trial judge to come up with that close of a call. And let's remember, these questions have to do with awarding money, which they didn't do. They never got there. Juries deliberate. In my experience, and it's been before you too, I think we all have the same experience, those questions come in on a lot of trials, and they're tough. What do you do? Some of them, I guess, are easy, like may we have a calculator is one that we don't like to hear. Maybe Mr. Shanks might disagree with that proposition, but sometimes they're kind of tough to answer. And that's why I think your rules of civil procedure say it's a may situation for the court.
But as to the second question, I call it, it's not really uniform, the Iowa Bar Association instruction explains why the settling party's there. So it could have been explained by giving note 6 of the Iowa Bar Association instruction.
Except for, if you look deeper, and this isn't in the record, but I'll just say, settling party was something we never could go into in that courtroom. It was released party, and that left everybody with a complete blank.
Well, they're interchangeable, settling or release party.
Well, we argued that, and if you would have seen our record, maybe you would agree, but I would disagree that I think that it's confusing. And so that wasn't gone into. Now, my time's up, but if I will be happy to answer any more questions, or I should say, try to answer some of these questions. But we're going to ask you, in sum, to restore this jury verdict. The Judge Steensland found in his ruling on the motion for new trial that a fair trial was given. The Court of Appeals said there was no abuse of discretion, and even the dissent in the Court of Appeals starts off with, I too do not find the district court's reasoning to be clearly untenable or unreasonable. And that's the standard we're here on. I thank you for your consideration.
Mr. Shanks, you have any rebuttal?
Just a couple points, Your Honors. What we do know is that there was a long, hard-fought battle, and we did our best to put the instructions together, and the jury did their best to render their decision according to the instructions. And we know that they needed help. I mean, we do know that from the questions. And the fact that they got to the point where they were talking about comparing fault of the parties, there was a process going on back there. We don't know who was against who, as often is the case, but we do know that the process was going on. And when they reached out for help and they said, we're confused, Judge, can you answer? Especially question number 1. Very simple, and that's what I asked Judge Steensland to do. I said, could you just answer yes? That's a correct statement of law. It's going to take care of everything. And I did say to the second one, I said, that's a little dicier, and I think that is covered in the instructions. Just refer them back. But that first one, Judge, I said that should be yes. And as we were talking, and I know this isn't part of the record, but Judge Steensland gave us his thoughts on what happens if a trial judge starts answering jury questions. He said, my experience has been if I answer one, they're going to have another question and another question. And one of the things I said was, well, what's wrong with that? If our ultimate goal is to see that justice is done and we want the jurors to be equipped with the law, so they can apply the facts to the law, then what's wrong with answering questions? Who says these jury instructions are perfect? Because
Counsel, in your experience, sometimes these juror questions are just attributable to one juror's curiosity, perhaps? And how do we know that's not what happened here?
well, we don't. We don't know which way that went.
Hypothetically, if there was an actual instructional error on a causation or comparative fault or damages instruction, would that be reversible error when the jury answered no to the first question, found no negligence?
If they didn't have a question, no, I don't think it would be. But I think if they pose a question and it's a legitimate question and you can look at it and say, okay, we didn't cover that, that needs to be answered. And it was substantial to the jury. They were concerned enough about that, for whatever reason, that they wanted an answer. And in answer to your question, Justice, what's in play here? Well, I think it's simply educating the jury as to what the law is, so they can make a decision, and at the end of the day, both sides can say, we had a fair trial, because the jury was fully informed on what the law is in Iowa. And that piece of that puzzle was missing in this case, and that's why we asked this court to take further review of the lower court's decision and respectfully request that Mandy be granted a new trial. Thank you.
Thank you very much, Mr. Shanks. This case is considered to be submitted, and you may recess court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.